Hearing in the appeals of the State of Mauritius and another against the Mauritius Seating Power Limited and others.
Now, I wonder, can I just check, first of all, that you can hear us and see us all right in Mauritius?
Yes, good afternoon, my lord. Yes, we can.
Fine. Now, we're going to be hearing first from Mr. Guthrie on behalf of the appellants. It's occurred to me to wonder if it might not make sense for us then to hear Mr. Chetty as his clients are supporting the position of Mr. Guthrie's clients, and then come to Ms. Bassett after that. Would that be acceptable to everybody?
Yes, my lord.
Yes, my lord.
Are you happy with that, Ms. Chetty?
Yes, my lord.
Yes, fine. Oh, sorry, yes. Fine. Mr. Guthrie.
My lords, it's apparent, I think, from what you've already said, that you're aware of the representation.
Yes.
My lords, the issues in the appeals fall into two parts. The first is whether the Supreme Court was right to find that the respondents' claims were properly brought by way of judicial review. And the second relates to the general merits of the Supreme Court's decision. Well, can I deal, please, with the amenity to judicial review first, and begin by asking your lordships whether you have a supplementary note which was lodged with the board,
Yes.
the purpose of which is to bring you up to date with the position in Mauritius.
This deals with the damages claim. Yes.
Hesitating because I see that not all your lordships have got it.
No.
Well, it doesn't seem to have come up in the
It's not on the electronic bundle, I'm afraid, because I was not aware of the present position at the time that the electronic bundle was put together. Hard copies, sufficient numbers were lost.
we've got various additional authorities in electronically, but this isn't electronically available at all, Mr. Guthrie, no?
I'm afraid not. It's probably have appreciated from pre-reading that there is a concurrent action
Yes.
for damages.
Yeah.
It's referred to in paragraph 89 of the respondent's printed case.
Mm-hmm.
But I thought I ought to show it to you really right at the outset, because it is say of the appeals.
Yes. Well, how's the clip or bundle referred to? I mean, is it has it got a title?
The supplementary note is very short, just 2 paragraphs.
It looks like this, doesn't it?
Yes.
On the front, but it's in a hard
Oh, right.
binding.
I mean, I've read it, so that could just be passed along.
Do-
I'm familiar with the
Oh, is it a supplementary note? Is that what it's called?
That's what it's called, but attached to it, I would
Well,
say.
don't worry, so long as we can identify the... Yes, and there's... Oh, supplementary note. Robert.
Yes, I know. I've read it.
It would help in due course if it could be emailed.
I'll make sure that's done, yes. Yeah.
Then we have it, those who operate on mainly electronic files will be...
I do understand, and I apologise that it's
Yes,
had to
I have it
come.
now, Mr. Guthrie.
I apologise it has to come in. It's come in this form, but it is the note itself is very short and just draws
Yes.
attention to the fact that these proceedings have now progressed in Mauritius. But attached to it is the amended plaint with summons. I can tell your lordship that the unamended plaint was, well, it was pleaded on the 15th of March and I think filed with the court on the 28th of March 2017. We have the up-to-date pleading, which I think is as far as the case has now got. There's been some preliminary hearings in relation to the provision of particulars and so forth, but that's as far as it goes. You will see that the plaint is based on tort, and it alleges that the state is liable for the faute lourde of the appellants in the present appeal, in other words, the two ministries, among others. And my Lady Black and my Lord Briggs may recall that the concept of faute lourde was something which was considered an appeal at the end of last year. And indeed, there was a case in which an action was made against customs officers and policemen, and it was found not to be sufficiently pleaded that they were guilty of faute lourde, so consequently there was no liability. It's a common concept in Mauritius civil law that an action against public authorities must plead and prove faute lourde. Of course, it does not have to have any element of straightforward civil action. You'll see that the plaint with summons, the amended plaint with summons that I've asked you to look at, contains a lengthy narrative. And I don't obviously ask you to read it now, but you will find that it repeats, relies on pretty much exactly the same material as relied on in the judicial review proceedings, which I can remind you involve two challenge decisions. One is the failure of the Ministry of Finance to confirm that the respondent had complied with the condition 15, and the other is the failure of the Ministry of Energy to sign an implementation agreement. And you'll see that in the amended plaint with summons, the facts and allegations about both those decisions are fully set out. For reference purposes, condition 15 is pleaded in paragraphs 32 and 61. The implementation agreement is pleaded at paragraph 69. The pleading refers to the judicial review proceedings at paragraphs 81 to 86, which is on pages 19 to 21 of the plaint with summons. Simply recites the story, if you like. And then at paragraph 86, it recites the findings and declarations which were made by the Supreme Court in the judicial review case, the one which is presently under appeal. And then it records that that judgment is on appeal to the Judicial Committee and that the appeal is being resisted. And then if I ask you to look at paragraph 91, you will see that it is said that the above particularized acts and doings of the Minister of Finance, the Ministry of Finance, the Ministry of Energy, and the Ministry of Energy, and others, amount to faute lourde, and that they're liable as proposé, that is, servants or agents of the state, which is liable as commettant, as principal. So what is being said is that exactly the same matters as were being litigated in the judicial proceedings give rise to the ordinary civil claim in tort as a result of faute lourde. And if you go to the last page of the pleading, you'll see that the result is said to be a claim for damages in quite substantial amounts, totaling some almost 31 million US dollars and 453,355,000 rupees, which, just for interest, is £77.5 million or thereabouts. So, Lord, exactly the same matters are apparently going to be litigated in a civil claim. And of course, we say that the claims ought always to be made in this way and not as matters of judicial review, to be seen as claims in private rather than in public law. My Lords, the respondent has put forward as justification for bringing claims by way of judicial review a number of matters. Perhaps I can tell your Lordships that the Court of Appeal in Mauritius were told when the application for leave to appeal to your Lordship's board was made. This is at page 928 of the record. That the judgments which we sought to appeal against was fundamental to the respondent's claim for damages, which the respondent intended to pursue, and that is what resulted in the pleading which I've just shown you. My Lords, the Court of Appeal granted conditional leave and then final leave under the provision of the Constitution which says that there's an important matter which deserves to be considered by your Lordship's board. Unfortunately, and this caused an interlocutory hearing before your Lordship's board in the past, they didn't say in terms what they regarded that important constitutional matter to be, but it may be that it is the questions whether or not it is proper to proceed by way of judicial review with, if you like, a whopping claim for damages up your sleeve, which is going to be gone into in due course. But the it is difficult to see why a claim for judicial review as a prelude should be considered as fundamental to a subsequent claim for damages, because the allegations being made, as you will see, are in fact exactly the same. And the judicial review application proceeded on exactly the same basis, in other words, on the basis that the second appellant, the Minister of Finance, was wrong not to have accepted that condition 15 had been satisfied, and that the third appellant, Minister of MJ, was wrong not to have signed the implementation agreement. And one can see that that was exactly what was always intended to be alleged from the notices mise en demeure, which I think your Lordships will probably know from previous Mauritius appeals, are formal letters before action. And we have them in the first bundle, if you're using the hard copies, at pages 105 and 162. At page 105, we have the notice mise en demeure against the Minister of Energy, and you'll see that that sets out in terms that CT Power is of the view that the proof of financial capabilities was never a condition which had to be satisfied before the signature of the implementation agreement. So exactly the same point is being made there in relation to the implementation agreement as being made now. And at page 162, we find the same notice mise en demeure directed to the Minister of Finance, where it is said that CT Power is of the view that it has satisfied condition 15 of its EIA license. So that these are exactly the same matters. And when the notice of motion was filed for the judicial review proceedings, which is at the very beginning of the bundles at page 4, you will see that what was being sought at that stage was at 2, a declaration that the applicant had complied with condition 15, and an order of mandamus directing the Minister of Energy to sign the agreed version of the implementation agreement. So the situation has always been the same, and in our submission, it is abusive in those circumstances simply to bring two sets of proceedings. The Respondent has made a number of other suggestions as to why this is not inappropriate. It's suggested that the position they found themselves in meant that they couldn't seek damages in a judicial review claim. Well, that is simply wrong in our respectful submission, because the law in Mauritius does provide for damages to be sought in judicial review proceedings, but I can take you to the authorities for that if necessary. Mr. Bassett was asked about it in terms in the hearing by the Supreme Court, and we see that at page 722. This is really probably the only point at which the Court of Appeal asked about this. But I'm sorry, not the Court of Appeal, the Supreme Court asked about this. They say, have you not asked for damages? And he says, no, it would not be appropriate for us to ask for damages in Mauritius in a judicial review application. Mr. Pandey tried that, and he was told, come again with a civil claim. And even MTEL tried that, and he still had to pursue a civil remedy. So this is not something which is common in Mauritius. But, my lords, those statements as to the law in Mauritius are, we say, demonstrably wrong. Pandey, we do have in the bundle, it's a very short point in the report. It's at divider 15 on page 1366. It's a case in which in fact, I represented Mr. Pandey, who was a magistrate who his appointment was determined, and it was found that it shouldn't have been. At paragraph 22 of the report, there's a reference to damages, and in the second half of the paragraph, their lordships consider that it would be unfortunate if, following a successful application for judicial review, a court were unable to award arrears of salary or give consequential redress that was otherwise appropriate, but had to remit the matter to be decided in separate civil proceedings before another court. A court dealing with a judicial review application can either assess the appropriate award itself, or can, if factual or other issues require further evidence or argument, order a trial of such issues separately, giving such directions as may be appropriate for the further conduct of the proceedings. And in fact, Mr. Pandey's case did go back, and you may have picked up from Mr. Bassett's case that he considers I looked at the wrong Pandey. It did go back for reconsideration by the Supreme Court, and we find that at divider 25 on page 1592. The short point is really this. The Supreme Court referred to the decision of the Judicial Committee this is on page 1592, electronics, the third page of the report, and then say what has to be set out at this juncture and what is agreed by the parties is the correct procedural process to be adopted for such a determination. And then they do exactly that. And on page 1594, we see the judge saying he directs that for the purposes of the present proceedings, the Supreme Court rules and the law applicable to civil procedure and evidence in respect of a civil claim shall govern the proceedings. It is just and equitable to do so in the absence of any prescribed procedure. I also ask you, if you would, very briefly to look at the MTEL case, which is at tab 8. That is on passages on page 1238. That was a case which was, if you like, the opposite situation to the one which confronts us today. What had happened was that the Supreme Court in Mauritius had wrongly refused a judicial review application, which the board in due course found that they should have allowed. And the question arose, what should be done about that in the context of civil proceedings which had been brought? And we see the passage in the judgment of Lord Bingham on page 1238. It remains to consider whether leave to apply should at this stage be granted, or whether, having regard to the changed statutory framework and the initiation of civil proceedings by MTEL, leave should be refused as serving no useful purpose. This submission has caused the board to hesitate, but at present the judgment of the Supreme Court when refusing leave still stands, and as long as it stands, it represents a potential obstacle which MTEL must overcome in pursuing its civil claim. On balance, it is right that leave to apply should be granted. However, that application should hereafter be handled in relation to the civil claim is a matter on which the Supreme Court is very much better fitted to rule, that is the board. And I will in fact take you to see what happened at that stage. But we would say that in the present case, the judgment in the Supreme Court is something of an obstacle to us in our proper defence in the civil claim.
Sorry, why does that make it an abuse that the JR proceeding should have been brought?
Well, my Lord, the reason that it is an abuse is that because it must have been foreseen that the civil claim was going to be brought. In fact, we know that it was foreseen because the court was effectively told so. So we have our other objections to the JR proceedings as well, as your Lordship knows from our case. But the fact is that it should not be, in our respectful submission, regarded as a prelude, if you like, to have two bites of the cherry. If you know you're going to take the second bite, to have the first bite, and, so to speak, keep the claim for damages up your sleeve, in which you're making precisely the same allegations.
But are you really going to get two bites at the cherry? I mean, if CT had lost the judicial review proceedings, wouldn't the relevant issues then become res judicata as between CT and the government in exactly the same way that you're objecting, in effect, to them being res judicata against you because you lost?
Well, I wouldn't go so far as to say they become res judicata. They're going to have to be gone into by a different court on a different occasion.
But I mean, insofar as the issues are the same, there may be differences which mean that they're not exactly the same, but insofar as they are the same, I would have thought that they were res judicata, having been argued through and definitively resolved.
Well, of course, they were argued on the basis of certain affidavit evidence, and there were disputes on the facts in front of the judicial review, which were not resolved by the court. We'll come to that when I look at the merits of the decision, but this is the fact of the matter. Because the matter was dealt with on the judicial review proceedings, and we say mistakenly decided by the court, we are faced with findings against us which we don't accept, and were made on the basis of affidavit evidence which at best revealed a dispute between the parties as to what had happened, and those disputes weren't resolved. So we say that the judgment should be set aside.
Right, I mean, I can see that as a potential ground of attack on the judicial review judgment, but, well, speaking for myself, it still seems to me that unless you can attack that judgment, insofar as the issues are the same, they would be res judicata.
Well, I am proposing to attack the judgment shortly.
Well, yeah, but at the moment, you seem to be making a point that it's somehow abusive.
Well, Lord, the reason I do that is partly on the basis of what happened in the MTEL case after the stage that the Privy Council looked at it, because they sent it back to the Supreme Court in Mauritius. And we have that report copied separately, and I wonder if that could be passed to your lordships.
While that's being done, you're not suggesting, are you, that where judicial review and a claim for damages, civil claim for damages, are both available to an individual, that proceed with the judicial review application is in every circumstance going to be abusive?
No, absolutely not.
No.
What I'm suggesting is that where it is apparent to the claimant that what he is going to do is bring a civil claim for damages, then he should do that and not bring the, if you like, the prelude proceedings by way of judicial review.
Well, the important words in that answer is when it is apparent to the plaintiff or the claimant that that's what he's going to do. I mean, a claimant confronted by two options might well elect to pursue the judicial review route and then decide to proceed with a civil claim. Is there anything wrong with that as a matter of principle?
Well, my Lord, if the allegations are exactly the same, as a matter of principle, it is duplicitous. I say duplicitous, I'm not sure if that's quite the right word. I don't mean any sort of...
Duplicative.
Duplicatory.
Duplicatory, yes, I'm very grateful. And that does seem to be the view which is taken by the courts in Mauritius, which is why I've asked for this case to be handed to you. We have sufficient copies on the end of the...
The relief's not the same, though, that's being sought in these, because there's a mandamus application in the judicial review.
But it wasn't pursued, the mandamus application.
But you could see that a judicial review might produce a more immediate and practical solution, which would then reduce the damages claim in civil action.
No, well, yes, I'm not suggesting that it is necessarily an abuse. In fact, I may have gone slightly too far when I used that word in the first place. But the question at the end of the day is what your lordships are going to feel is the right course to take in the appeal, having the knowledge that has something gone wrong with the
Possibly
machine.
something has. Yes. Mr. Bassett, are you able to hear us? No. Well, we better do something about it. Well, I'm sorry we lost you, Mr. Bassett, but we stopped the proceedings as soon as we noticed that the signal had been lost. So you haven't missed anything.
Thank you.
Well, my lord, we did manage to have a quick word with Mr. Bassett, and I think the last thing he saw really was my Lady Black's intervention.
Yes.
Obviously, I won't ask her to make it again, but I understand that the point that she wished to make to me was that the relief sought in judicial review proceedings might be different and might be better from the claimant's point of view than in the eventual civil claim.
Or more immediate.
Or more immediate, and that referred to mandamus. My lords, I obviously accept that, but I think I can underline that that doesn't seem to have been the reason that that course was pursued in the present case. I've already told you that the applicant gave us a reason that he couldn't recover damages in the judicial review proceedings. And in his written case, he deals with this in paragraph 93 on page 1092.
So given that number again, please.
1092.
1092, thank you.
And what he says in paragraph 93 is this: the claim of CT power for damages cannot be grounded in contract, as there's no contract between it and the state. In order to establish a claim in tort under Article 1384 of the Civil Code, CT power has to identify the faute lourde or misfeasance of an identifiable préposé or agent acting in the course of his public duties, which is capable of attracting the liability of the state as commettant or principal. But for the judicial review application on the merits, which forced the appellants to come out of the woods and state for what reason CT Power had allegedly not met one of its license conditions, CT Power would not have been able to articulate any case it taught against the state. Now, we respectfully submit that that is plainly not right, because the same allegations could have been made at the outset as were made in the judicial review proceedings.
Well, let's suppose you're entirely right about that, it was at the option of the claimant to decide to proceed with judicial review proceedings, and he could have claimed damages in the course of the JR application. But the basis on which he could have promoted the JR application was different from a tort claim. I mean, is there anything abusive about his opting for the judicial review route first?
Well, I think abusive may, as I've said, be too strong a word.
Well, is there anything...
As I say, we're going to come to a point, if I'm right about other submissions, of your lordships deciding what to do, and if you were to feel that there was justification and bringing judicial review proceedings, but that justification no longer exists, there would be no useful, and there were good reasons to complain about the judicial review conclusion. Then you would be confronted, if you like, with the same situation as confronted Lord Bingham at the end of the MTEL case as to what should be done, bearing in mind the ongoing civil proceedings. But
it just occurs to me it might be more profitable to concentrate on what certainly I, and I think possibly other members of the board, consider to be your principal case, namely that this was not a case which was suitable for judicial review.
Well, I'm certainly happy to take up that invitation before I go to it.
Oh, yes, of course.
Just one matter, which I think is relevant. The other justification which you've just seen for the jail proceedings appears to have been to bring us out of the woods. That can't be right, with respect, because there's exactly the same procedures by way of interrogatories, discovery, etc., would be better, or would be as good, if not better, in a civil claim. And I should, to complete the MTEL story, if you like, show you the short report of what happened when it went back, because you'll recall Lord Bingham saying it was up to the Supreme Court to decide what to do with that application. I have, I think, had put before you the report from the Supreme Court in the MTEL case, which took up the invitation. On the second page, you'll see that counsel for the respondent and the co-respondents took a preliminary objection that in view of the fact that the applicant had a civil claim against all their clients on substantially the same matters mentioned in its application, the applicant should elect to pursue either its application or the civil claim, but not both, given that the long-standing and consistent procedural practice of this court, unlike the courts of England, that court says, is not to allow parallel judicial review proceedings and a civil claim, or a joinder of judicial review proceedings and a civil claim. It's an uncontested fact that the practice of this court has always been to maintain at all costs a procedural divide between public law and private law proceedings, and not to allow them to merge in a joint action or to run concurrently, the more so when they deal essentially with the same matters. And that was the case in the MTEL proceedings, and so they struck out the application for judicial review. So that really is the last point on my preliminary.
Yes.
So if I can deal with the substantive points to be made on the two relevant decisions, why we say that judicial review didn't lie in any event. Can I deal first with the Ministry of Finance's refusal to confirm that condition 15 was satisfied? My Lords, that condition is to be found in an EIA, Environmental Impact Assessment license, dated the 23rd of January 2013, and it's at pages 383 to 9 in the electronic bundle.
Is that the same as the one at page 29?
It probably is. It's as far as I know, there's only one which it could be.
Looks like it.
You'll see that the license is issued under the Environment Protection Act, and as you might expect, it's principally concerned with protection of the environment. So we see various provisions about control of gases, particulates, relating to the transportation of coal, etc. The only exception to that is condition 15, about which the first thing to say is it has nothing to do with environmental impact at all. You know what it says. It's to do with providing proof by the developer of its financial capabilities for the duration of the project to the satisfaction of the Ministry of Finance.
I mean, in fact, condition 25 also isn't purely environmental. I mean, I rather took it that often environmental projects are allowed to go forward because of public benefits that they will provide, even though at some cost to the environment. So I rather thought that, for instance, condition 25 was seeking to secure an aspect of public benefit.
Well, from an environmental impact point of view there, because community enhancement, a corporate social responsibility program, I certainly read those as being, if you like, attached to the obvious environmental points, right, such as not destroying the area and keeping it clean and healthy and so forth. But it has nothing to do with condition 15, which is, as we say, limited to finance. And we do have some evidence.
So, it's a small point, but actually the proponent is CT Power, isn't it?
Yes.
So why isn't funding of the community fund by CT Power dependent on CT Power having the funds to do that, amongst other things?
Well, amongst other things, but the purpose of the of condition 25 is to ensure community enhancement.
Yes, but sorry, you said that's got nothing to do with condition 15. That's what I was just...
Well, I don't think it does, with respect. It's quite a different aspect of the license.
Right.
The point about the community fund is to ensure, as it says, to cover areas such as community enhancements, provisions of community facilities, education, etc., community liaison arrangements. When I read that as being part and parcel of the general scheme to protect the environment where the plant is going to be established.
But it isn't going to help the environment if the proponent ceases to have funding partway through the project.
Not going to help it, no. But this is addressing a different matter. I mean, it is unusual to find a provision like this in an environment protection license, and that has been accepted by everybody from the word go. But we know why it was inserted, because there's evidence to that effect.
But forgive me, why isn't it relevant to environmental protection that one has assurance that the scheme will be completed rather than falter halfway through with huge environmental detriments from all the building work and so on, without the public benefits being sought to be achieved by the project?
Well, the environmental protection aspects of the matter under the license and for the protection of the environment in pursuit of the objects of the Act are really seen in all of the provisions of the license apart from this one. This one is simply dealing with the financial capabilities of the developer.
But I think what I'm putting to you is that doesn't that have an impact on the environmental position? Because if the developer is not funded in such a way that they can complete the project, what you will end up with is huge environmental detriments as the project is pursued halfway through without taking it through to completion and securing the public benefits.
Well, I understand that, but I mean, that could be said about if the, in relation to any of the banking arrangements which were made by CT Power, I mean, you can say that I would respectfully submit that there's an obvious division between what is intended to protect the environment, if you like, and what is intended to guarantee the financial suitability of the developer.
Yes,
that is why the license is. I mean, if one looks at the Act, the objects of the Act are to protect the environment. But I see what your Lordship is saying, but I would respectfully submit that there's a clear distinction to be drawn between matters which are focused on the environment protection and matters which are, if you like, very much ancillary to it, and which do not, in fact, as is quite clear, even concern the Minister of the Environment, who is the person who grants this license. I mean, this is a matter for the Ministry of Finance, and is quite outside the arrangements which are being made for the Ministry of the Environment to grant the Environment Protection License.
I remember when I used to do planning work at the bar, it was quite common for there to be bonds required to satisfy the planning authority that, for example, the roads on a housing development would actually be built and completed. Because otherwise, if only the houses went up and the developer went bust, it would be the local authority that would have to pick up the bill.
Well, the question really is whether this is really properly to be seen as part of the public duties which are bestowed by the Environment Protection Act on the Minister of Energy, or something completely different, and we say it's something completely different.
I'm wondering what the point is of you're raising the issue.
Yes.
Nobody's challenging the vires of Condition 50.
Well, that's true, yes.
Oh.
Yeah. Well, the point is whether or not it should be probably the subject of judicial review. I mean, we say that that it is something which was inserted for a particular purpose, and the evidence shows that it was a decision taken by the Cabinet for financial reasons, and not a decision which was part of the statutory powers of the Minister of the Environment or the Minister of Energy. And so...
Well, if we're treating it... If in the absence of any challenge to its vires, we have to treat this as a valid condition, then it must be one properly imposed by the Ministry of Environment in the exercise of its powers.
Yes, well, in fact, in my learned friend's case, he says it wasn't, but as a matter of fact, it has been accepted as being, as your Lordship has pointed out. He says that it should never have been imposed in the first place because it wasn't something which was within the... But he also accepts that it was binding. Well, I was going to take you, but I think perhaps in view of what we've said, and just give you the references to this. The evidence about why Condition 15 was included is in the evidence of Mrs. Orjeet, who is the deponent on behalf of the Minister, on behalf of the Minister of Finance, at page 500, 575, isn't it? I hope I've got that right. It's at page 575.
Yes, looks good.
So she's on behalf of the Minister of Energy, but she sets out on page 575 the reason why the condition was included, and she exhibits the statement which was made by the Minister of Finance, Mr. Duval, and that's to be found at pages 581 to 83. Well, we made the point that it's not really anything to do with environmental impact, which is what the license is concerned, but I've heard your Lordship's response to that, and I won't labour the point. Also accepted that its validity is accepted by the respondent, who indeed attempted to comply with it. And, the evidence of that, I think, we find at page 265.
I'm so sorry, what did you want us to look at on page 265?
Page 265, that is really the evidence that the respondent accepted the validity of the condition and sought to comply with it. You'll see that in paragraph 29, they say that in seeking to comply with it, they secured letters from 2 major international banks, and I'll come back to that in due course. It was their case before the Supreme Court. By obtaining those letters, they had complied with the condition. But as the summary of those submissions would be, our first point was that if the Minister of Finance was wrong to refuse to accept that Condition 15 had been complied with, then that was a matter for the ordinary civil claim and not a matter for judicial review. And we know that he was capable of making exactly the same allegations at the outset. So if I move on to the linked decision by the Minister of the Environment not to sign the implementation agreement, your Lordships know that that agreement was intended to provide a guarantee by the state for the liabilities of the Central Electricity Board to the respondent under the power purchase agreement. In other words, to guarantee the payments by the board for the electricity generated by the plant. I wanted to take your Lordships to the respondent's evidence about that at page 271 of the record. That's in the affidavit of Mrs. Joa here. She says in paragraph 58, at the bottom of that page, as far back as January 2009, the main terms of the implementation agreement had been settled with the representatives of the Ministry of Energy. Over the page, after several consultations and amendments, a final agreed draft was circulated on the 21st of July 2014. Despite several reminders and service of a letter dated the 5th of December, the Ministry of Energy has refused to sign the implementation agreement. There was, in fact, an earlier version of the draft implementation agreement, but I think perhaps it's not necessary to take your lordships to see it, because it was in 2009, which was a long time before the eventual grant of the EIA license, and was plainly superseded at a later stage. But I would ask you to look at the what's referred to by Mrs. Joa here as the final agreed draft, because in summary, it's nothing of the sort. Your lordships will find it at page 431. Unfortunately, the writing isn't terribly clear on the copies. But you'll see that this document is described at its head as an implementation agreement draft dated 21st of July 2014, joint discussion draft between MCTP, that's CT Power, and the Ministry of Energy and Public Utilities on 18th of July 2014. It's plainly not in its final form at all. We can say that because we can see the tracked changes, which are not tracked changes as such, but comments which are made on the first draft. You'll see the, so I can just take you to some of the document. Clause 4 on page 437 is the clause which explains the guarantee. The government of Mauritius irrevocably...
Sorry, which 437?
Yes, should
Thank
be.
you.
437. The GOM, Government of Mauritius, that's 411, irrevocably and unconditionally guarantees Mauritius CT Power Limited, jointly and severally with CEB, as co-principal debtor, the due and punctual performance of each of CEB's payment obligations, undertakes that it will in any event pay any sum, etc. So it is a provision which in due course is intended to guarantee payment by the electricity board for the powers generated by CT Power, which is, so to speak, we would say not a public law matter at all, but a matter of practice. If I ask you to go to condition 7, this was in fact new. In other words, it has no predecessor in the 2009 agreement. You'll see that the condition refers in paragraph 7.1 to what would be condition 15. The GOM and CT Power hereby acknowledge and accept that this agreement is subject to CT Power providing proof of its financial capabilities for the duration of the product to the satisfaction of the Ministry of Finance and Economic Development within 9 months from the date of this agreement. For the avoidance of doubt, CT Power shall be deemed to have satisfied the condition and as stipulated and condition 15 of the EIA license by achieving financial close. In the event the condition set out in clause 7 is not met, the parties agree that this agreement shall lapse and be of no further effect. There then, my lords, is a note. I mean, obviously, as you know, our position is that this was never agreed. There is then a note. This condition has been included at the request of the Ministry of Finance and Economic Development, who have confirmed that if condition 15 of the EIA is included in the period with a 9-month time frame, the proposed amendments to the implementation agreement as per our earlier draft, dated 4th of July, are acceptable. This is to impose a time frame in line with the long stop date under the PPA to achieve financial close. In line with this request, and to avoid any further ambiguity on this condition, and to also prevent further delays on the project itself, we have inserted the provisions of Clause 7.2 to clearly stipulate that once we have executed all our financing documents showing preparedness to draw down and commence construction, we would be deemed to have satisfied this condition. We hope this is in line with the expectations of the government of Mauritius. It is impossible in our respectful submission to look at this as a final agreement which could simply have been signed then and there. It is still in the form of a discussion draft. The other condition it's worth looking at this point, while you have the implementation agreement open in front of you, is condition 12.7, which is on page 446. I refer to this because the Supreme Court does in due course. Waiver of sovereign immunity. The government of Mauritius unconditionally and irrevocably agrees that the execution, delivery and performance by it of this agreement constitute private and commercial acts rather than public or governmental acts, and waives any right of immunity which it or any of its assets now has or may acquire in the future in any jurisdiction. Consents generally in respect to the enforcement of any award or judgment against it in respect of any litigation or arbitration proceedings in connection with this agreement in any jurisdiction to the giving of any relief or the issue of any process. Agrees that should any litigation or arbitration proceedings be brought, no immunity from such proceedings will be claimed. The acknowledgement which is attended that it is to be treated as a private and commercial act rather than as a part of the public.
Yeah. We can see on the previous page in the note under the heading 12A arbitration, the note ends with the words, please confirm acceptance. And I noticed also that there's a note at the top of page 442, just before clause 10, and that note ends, we hope you are able to accommodate this. So it clearly is a document being put forward by one party with a request to the other one to agree it.
Yes. And this is the agreement which is relied on by CT Power, which they refer to. I took you to the passage just now. I won't take you back to it as the final agreement. But as I respectfully submit, it is simply not. And again, I take the point. This is again the agreement which is relied on in the new complaint with summons, which I showed you earlier. Well, as to the law, whether this is properly the subject of judicial review, I think the matter can be dealt with fairly shortly. I hope that I can refer you to where we have set it out, as we say the law is, in our written case, which is at paragraphs 11 to 19. But I say that at this moment really only for reference purposes. I'm not proposing to ask you to read that again now. We suggest that the authorities, taken together, really establish the following propositions. The first is that judicial review is only appropriate where it can be said that the authorities have breached public law obligations. The second is that in order to decide that question, it is necessary to focus on the decision which is being challenged to see whether it is a decision made as a matter of such public law obligations or not. And the final and third proposition which we say is established is that the question is not decided by reference to the allegations which are being made, or by the identity of the decision maker, but by the nature of the decision itself. And we say that that's demonstrated by the authorities we rely on in our printed case, the first of which has some correspondence, if you like, to the facts of the present case, is the Mercury Energy case.
I wonder, the special feature of this case might be said to be the link between the decision whether the license condition had been fulfilled, on the one hand, and the decision whether to enter into the implementation agreement on the other. And on one view, the decision whether the license condition has been fulfilled is a decision taken in a public law capacity, because the condition is obviously a condition imposed under statutory powers. And the question which may then arise is how, if it's accepted that that decision is of a public law character and susceptible to JR, whether that means that the consequent decision to decline to enter into the implementation agreement on the basis that the condition had not been fulfilled is also given a public law character.
Well, yes, I see what your Lordship is saying, but there is a distinction which we say can be demonstrated by a comparison with the Mercury Energy case. If I can ask you to look at that, yep. It's at divider 12, and that means it's at page 1285, or it begins at page 1285. But the passage on which we rely is at page 12923. The Electricity Corporation, in that case, decided to determine a contract with its supplier, and that was found not to be amenable to judicial review. But it was contrasted with a decision to refuse to supply electricity at a reasonable price, which would have been subject to amenable to judicial review. If one looks at page 1292, it's a judgment of Lord Templeman between letters C and D. It was for the defendant, i.e. the Electricity Board, and nobody else to decide in its discretion whether the contractual arrangements with the plaintiff should be allowed to continue or should be determined. The court can only interfere if the plaintiff alleges and proves that the decision was not made according to law. The decision which is impugned is the decision to terminate the contractual arrangements. There has been no decision to refuse to supply electricity to the plaintiff at a price which the defendant believes to be reasonable, having regard to its statutory principal objective and to its statement of corporate intent. And the comment is made on page 1293, just above letter B. It does not seem likely that a decision by a state enterprise to enter into or determine a commercial contract to supply goods or services will ever be the subject of judicial review in the absence of fraud, corruption, or bad faith. In the lower paragraphs, between letters E and F, referring to the relevant statute, there is nothing in the Act of 1986 which imposes a statutory duty on the defendant to allow the contractual arrangements to continue. And then the next paragraph, the causes of action based on breach of statutory duty, abuse of a monopoly position, and administrative impropriety are only relevant if the causes of action based on contract are rejected. If the causes of action based on contract are rejected, the other causes of action will only constitute attempts to obtain by the declaration sought specific performance of a non-existing contract, the exploitation and extension of remedies such as judicial review beyond their proper sphere should not be encouraged. Similar points made. Well, the distinction is obviously between we would say in our case, between the objects of the environment impact assessment and the purely commercial arrangements which are required by the government to deal with the matter. Similar points are made in the other cases we rely on, and notably in the judgment of Mr. Justice Waller, as he was, and in Hibbett and Saunders, and Lords Justice Glidewell and Scott, as they then were, in Mass Energy Limited in Birmingham City Council. Perhaps it would be, I have set those out in some detail in paragraph 17 of my written case, which you'll find on page 1042. The passage from Mr. Justice Waller's judgment is a little difficult to find because it's easiest to find in the where it's quoted in the judgment of Men I Collect, but I've set it out. The judge said it's critical to identify the decision and the nature of the attack on it, unless there's a public law element in the decision, and unless the allegation involves suggested breaches of duties or obligations owed as a matter of public law, the decision will not be reviewed. It is not sufficient in order to create a public law obligation simply to say that the Lord Chancellor's Department is a governmental body carrying out governmental functions and appointing persons to public office. A governmental body is free to negotiate contracts, and it would need something additional to the simple fact that the governmental body was negotiating the contract to propose a public law in addition, a duty in addition to private law obligations. If a government body has a statutory obligation to negotiate a contract in a particular way, etc., or the right, they say the right must flow from the statute if it's going to attract judicial review. In the present case, we say both Condition 15 and the implementation agreement are not concerned with the duties which are on the Minister of the Environment and Minister of Energy, and the Minister of Finance under the legislation in connection with environmental impact at all, or indeed in relation.
Sorry, I mean, surely the Ministry of Finance's role, pursuant to Condition 15, is a public law matter. It's a public law obligation has been imposed on it to check whether the financing arrangements are satisfactory from an EIA point of view.
Well, those last words are where we may differ from an EIA point of view. We don't accept that it is from an EIA point of view. We say from what Mr. Duval said in Parliament, which I've set out, this was a purely financial matter.
But that rather goes back, doesn't it, to the point my Lord Reid made to you. It's almost as though you're now saying Condition 15 was ultra vires EIA, because it had nothing to do with EIA matters. But that's never been part of the case. And indeed, by inserting Condition 15, your own clients must have been asserting that it did have something to do with the environment. And one can see how it does, and we ventilated the reasons why it does.
I wonder if that was, in fact, the process of reasoning which led to Condition 15 being in the environmental impact licence. But I don't think I can really argue the point any further. I mean, your Lordship takes that view. Yeah. We submit that Condition 15 was inserted solely so that the finances could be found to be satisfactory at full stop, and that the implementation agreement is simply a guarantee. It wouldn't have mattered if it was gas, electricity, biscuits, or whatever it might have been. It's simply a straightforward commercial arrangement, which was never in the event implemented, but never in fact agreed.
You need it to be properly in as a condition, don't you, in order to run the rest of your case? Because it's not satisfied that the problem arises, isn't it?
Well, it could have been expressed in another way, but I mean, the fact is it was a condition. If that means that it must therefore come within the ambit of the same, it falls under the same umbrella as, for example, a condition that lorries should not dump their coal on them, then so be it. But it is quite of a different character, and we submit that the different character leads to a different jurisdiction. It leads to a civil claim rather than a judicial review claim. But I think your lordships have what we say about it, whether we're right or wrong. The situation with the implementation agreement, of course, is rather different because it was not actually signed, and indeed it never reached a state in which we say it could have been signed. Perhaps it's probably, looking at the time, because I only have my stipulated 2 hours, perhaps I should move on from general law, which I don't think is particularly contentious, as to what is look at the way in which this was dealt with by the Supreme Court. On the amenability point, we need to go to the decision at page 838. Begins at paragraph 38. And perhaps I can also just give you a cross-reference to our written case, which is at page 1047. The court indicates in paragraph 38 that the principles of the English cases are generally applicable. It then refers to 2 cases, Bywater and Atlas. The short point to be made about those is that they are both classic instances of breaches of a statutory duty. I've spelt that out in the written case, and perhaps it wouldn't be a particularly useful use of time to say the same thing again. But we can see in paragraph 41 the way in which the Supreme Court approached this issue. And it may be that there is a distinction to be drawn between the public law elements of Condition 15 on the one hand and the implementation agreement on the other. What they said was this: turning to the present application, the Minister of Energy, on whose path the point of jurisdiction is taken. Well, perhaps I can just pause there. The court said that, but it's quite clear that, in fact, from the word go, the point was taken by both the ministries, and I can take you to the original argument when the leave stage was being argued, if necessary. So the Minister of Energy, and one could add the Minister of Finance, on whose behalf is assigned under Section 6.2 of the Constitution responsibility for the conduct of the business of government, including responsibility for the administration of the ministry. The decision of the Minister and or the Ministry not to sign the implementation agreement has therefore a public law element. We complain about that as being a gross oversimplification of the position. It does not follow that anything a minister does is amenable to judicial review, but the Supreme Court plainly thought that it did. Then they continue, also, at the heart of the application of CT power are allegations of irrationality and illegality. It cannot, therefore, be said that the refusal to sign the implementation agreement can only give rise to private law remedies. That, we say, is also manifestly wrong. You cannot move something into the sphere of public law simply because you make a public law type of allegation. And we refer back to the law which is set out in my written case.
Would you accept that if a decision engages the public interest, I don't mean by that that the public is interested in the outcome of the decision, but it's a decision which affects the public interest, that will be an indicator that it falls within the realm of judicial review?
No, I wouldn't accept it as broadly as that, no.
Well, how would you narrow?
I would say that a straightforward decision by a government to guarantee the payments under a contract only has a public law element if it can be shown to be taken in the execution of a public duty.
Presumably,
otherwise, everything a minister ever did would be judicially reviewable.
What's the basis of the power to enter into the implementation agreement?
Well, it's a part of the ordinary government business of guaranteeing a payment.
But does it not ultimately have a statutory source?
Well, I thought not. I mean, it's being undertaken by a minister, but to say that because a minister is a minister, everything that he does is judicially reviewable because it's a matter of public is to go too far.
Yes, we know that the power purchase agreement was entered into by the Central Electricity Board under a statutory power. And that agreement, its parent department, as it's described, is the Ministry of Energy. And that agreement, seemingly, had contained a requirement that there be an implementation agreement. But nobody has tracked down any statutory provision under which such agreements can be entered into.
No, I say the court have simply assumed that because it's the ministry, it's judicially reviewable, and because it's said that it's irrational, it's administratively, it's judicially reviewable. That's where we raise an objection. It must. I mean, the same comment could have been made, if you like, in the cases of Mercury Energy and mass energy, which I refer to.
Well, that, of course, was said to be within the ambit of the judicial review jurisdiction. It's just that the grounds of judicial review would be very highly limited.
It said that the decision to determine the contract was not within the ambit of judicial review. That's what Mercury Energy said. It said that what would have been within the grounds of judicial review would have been any decision which impacted on the supply and the price of electricity. And in mass energy...
Oh, sorry, just on that, since we're on it, it's page 1293 in the combined bundle at letter B. Lord Templeman said, it does not seem likely that a decision by a state enterprise to enter into or determine a commercial contract to supply goods or services will ever be the subject of judicial review in the absence of fraud, corruption, or bad faith.
Yeah.
So that, what I was putting to you is, that seems to contemplate that in terms of jurisdiction, if you like, that it is possible to judicially review, but the grounds of judicial review will be highly limited.
But that case establishes two things. As your Lordship says, it establishes that the grounds of judicial review will be extremely limited, and to the grounds which he sets out. But it also establishes that the determination of a contract for contractual reasons will not be within the grounds of judicial review, unless that is the case. And the reason it is not is because it is not in the exercise of a statutory or public duty.
Well, first of all, I thought we were talking about a decision to enter into a commercial contract in our case.
But yes, well, mutatis mutandis, surely that leads to the same result.
Well, sorry, the same result as Lord Templeman said.
Yes, if we had refused to enter into it as a ground of bad faith, then, my learned friend, this is not something that the court found.
No, I appreciate that.
But surely the converse holds good. I mean, what Lord Templeman is saying, forgive me if I find the point, is that...
sorry, it's page 1293 was the
Yeah.
passage that I drew your attention to.
But it's what he's saying at 1292 is that the decision, a distinction is to be drawn between the decision to terminate contractual arrangements, which is not reviewable in the absence of bad faith, etc.
So even that would be reviewable
It would be,
if there was
yes,
bad faith?
if there was bad faith. But that is not a feature of this case.
No, that I follow, but you...
But if
may
it
be
isn't
that there
a
are
feature...
subtle differences in the way in which the case can be put. You seem to be making, well, as it seemed to me, on my understanding, a more extreme submission that one simply could never have judicial review of a decision of this character, whether or not to enter into a commercial contract.
Well, in that case,
whatever public law style objections there might be to it, for instance, bad faith, corruption, and so on.
No, what I'm saying is that it is wrong to test the question by looking at the allegations. You need to look at the decision.
But I thought, actually, you're accepting that you do test it to some degree by looking at the allegations, because if the allegation was bad faith...
Yes, to that degree, but to that degree only.
Right.
But I think the proposition that was put to me that what these ministers are doing must be under some statutory prior or other, even if we haven't identified it, so that it must be judicially reviewable. Well, that point could be made in relation to the Mercury case, in relation to the decision that they said was not reviewable, because the Central Electricity Board must have been, because it was a statutory body, if you like, associated with some sort of statutory authority which allowed it to make contracts at all. And if one looked at the mass energy case, which is the...
Before you move from Mercury, wasn't that a case of terminating a contract?
It was.
Isn't a termination of a contract different because you have the terms of the contract to consider?
Yes,
You're acting as a contracting party,
but
rather than as a public body, necessarily. You might be acting
Well-
as a public body as well.
Well, according to... you would not be amenable to judicial review in relation to the contractual element.
No.
But
But that's not surprising when you've got a contract in existence, is it?
But I would have submitted that the authority is clear enough, saying that only certain of the decisions which are made by the statutory body can properly be considered to be judicially reviewable. And the mass energy case says very much the same thing. But I think if I were to accept that Roger's proposition that all these must be linked to some sort of public duty, I would be almost going as far as the Supreme Court saying, well, they're decisions of ministers, they're ergo publicly reviewable, which I don't think are judicially reviewable, which in my understanding of the authorities is not the case.
If a decision to enforce Condition 15 in a particular instance could be demonstrated to lead to the collapse of electricity supply in Mauritius, would that be a judicially reviewable decision?
I think the Lordship's got me sort of against the wall, so to speak. I think it might be.
Well, what distinguishes such a decision from the decision in the present case?
Well, we know why the condition 15 was inserted, and it was to provide a financial guarantee. We know who it was inserted by the Cabinet, and we know that it was of a different character to any duty which is owed by the Ministry of Environment under the Environment Protection Act, which is the body which provides the licence. So it is a quite different character than the statutory duties which were in play when the licence was granted. Giving me an example which...
Well, obviously, it's an extreme example.
But I mean, it may be illustrated by, it may be relevant to look at the factual context in which the decision was taken. One can easily see that there are a lot of contracts that government departments take which don't involve the exercise of any governmental function. For example, if they're arranging the catering or the telephone services or the stationery supplies or whatever. There's nothing governmental. It just so happens that it's the Ministry of X which is entering into a contract with BT or whoever it is. On the other hand, if decisions are being taken by ministers and announced in Parliament, one might think that these are not ordinary commercial decisions, but are actually the exercise of governmental functions.
That might apply to Condition 15, but not to the implementation agreement, I should have thought. But in any event, the examples your Lordship gave me could almost be stretched by analogy with my Lord Kerr's example, to say, well, if there was no stationery in Parliament and they couldn't sign an act, wouldn't that have a public consequence, and
yes.
Wouldn't it be then judicially reviewable? The answer is obviously not.
Well, that may not be let me indicate that that's not the appropriate test, but I wonder if there may be something in asking whether it is a sort of, whether the contract in question is being entered into in the exercise of a governmental function or not.
Well, I think I'd better get on, actually, because I've
yes.
only got my 2 hours. And have my written submissions in any event.
Yes.
I think the one point on the matter which I was going to take you to is the mass energy case, because I have, it's in paragraph 17 of the case, and it's perhaps drawing the same distinction between a contract and other matters. Set out in that paragraph, perhaps needn't read what Justice Glidewell and Lord Justice Scott both said about that, which was that judicial review should be confined to be dealing with this was waste disposal authorities, their public law obligations in relation to the disposal of waste. And submit that the stretching it to find these particular decisions as being taken in of public duties. On the merits, my Lord, can I make a number of points to deal first of all with the implementation agreement, because that is the issue which was dealt with first by the Supreme Court. The relevant parts of the judgment are at 830, first of all. In paragraph 8, the court records the minister's position. The last part of that paragraph, the Ministry states that the draft circulated on 21st of July 2014 was still not final, as it was subject to the approval of Government and the Ministry of Finance. It further states that in the course of meetings of the 15th and 16th January 2015, CT Power was informed that the signing of the implementation agreement was subject to the submission of a letter of comfort as regards the financing of the project. When this issue is decided, we find this at page 840, under a subheading, the refusal to sign the implementation agreement. So coming to the application, we shall first deal with the refusal to sign the implementation agreement. On the unreasonableness of the refusal, CT Power relies strongly on Clause 7 of the draft. Annex 19 refers. Well, I've taken you to Clause 7. You'll recall that is the one which was subject to a note, which we went through. Clause 7 is then recited by the Supreme Court, but without noting that there was the note inserted below it. And you remember that's the note which concludes with the words, "We hope this is what the government of Mauritius will agree to," words to that effect. They then say, it is appropriate to put into context the importance of the signature of the implementation agreement, at least from the perspective of CT Power. According to CT Power, the signing of the implementation agreement, the draft of which had been circulated in agreed form ever since 21st of July 2014, is a critical security document which lenders have to see in its final form before issuing an expression of interest to meet the finding requirements of the project and all the final sanction of the funding facilities, be it debt or equity. And they refer to the paragraph in the relevant affidavit. We take into consideration, well, my Lord, perhaps before leaving that paragraph, we would respectfully submit that they were misleading themselves if they were regarding the importance of the signature, at least from the perspective of CT Power, as relevant. It's plainly important to everybody. But the fact is, the fact that one party very much hopes that an agreement is going to be signed doesn't give it a right to have it signed. In paragraph 46, we take into consideration the stand of the Ministry and Minister of Energy that the draft implementation agreement of 24th of July was subject to its approval and to that of the Ministry of Finance. However, it appears from Annex 19, that's the agreement itself, that the draft was also a joint discussion draft between MCTP, CT Power, and the Ministry of Energy and Public Utilities on the 18th of July. The fact that it's a joint discussion draft can't make it, so to speak, more binding. It simply emphasizes the fact that it's not. And they say, in any event, there does not appear to have been any dispute thereafter as to the terms of the agreement. Consequently, unless it can be shown that the contrary holds, there is a legitimate expectation that the parties will adhere to Condition 7, which states that CT Power is to provide proof of its financial capabilities within 9 months from the date of the agreement. Well, there was no such binding agreement, and unless there was a binding agreement, Clause 7 has no relevance to this matter. Really, that, in our respectful submission, either this was an agreement or it wasn't. Then we have, there is also the statement made on behalf of the Ministry that CT Power was informed in the course of the meetings held after the 5th of December that the signing of the implementation agreement would be subject to the submission of a letter of comfort. The affidavits exchanged refer to a meeting on the 15th of January, where the representatives of CT Power had a meeting with the Minister of Energy and his officers. CT Power denies that it was raised at that meeting that the signing of the implementation agreement would be subject to the submission of a comfort letter as to the financial capabilities of CT Power. It appears that no written communication of any decision, of if decision there was, to the new condition imposed by the Ministry of Energy and agreed upon by CT Power. Now that sentence doesn't seem to make complete sense. Possibly the word was should go before the word agreed, if decision there was imposed and was agreed by CT Power. But again, if there's to be a variation, there has to be an agreement to start with. And there plainly was not. And to say in the result there is substance in the contention of CT Power that the refusal of the Ministry of Energy to sign the implementation agreement is unreasonable, unfair, and against the legitimate expectation of CT Power is really, we would say, more or less inexplicable, because the court is faced with no more than a draft which is being circulated between the parties. On the this judgment, in our respectful submission, cannot be upheld in relation to these passages, which are simply wrong by demonstration, by comparison with the documents. Perhaps I can move on then to the position in relation to condition 15. The respondent's first case, as I think I've mentioned in passing so far, was that condition 15 had been complied with by a bank letter. And we find that at two places, really, pages 265 This is an affidavit in support of CT Power's case dated the 23rd of July 2015 by Mrs. Joy here. And she says, in furtherance of complying with condition 15, CT Power has secured, since the 10th of October, a letter from two major international banks, namely Bank of America and Bank of India, for the debt finance of the project up to the amount of $280 million. And then this is again their case at page 619. Where it is said, in paragraph 9.3, it's the same deponent, this time in an affidavit of the 8th of October 2015. The letters from the bank are referred to in paragraph 9.2. Then in paragraph 9.3, it said the amended letter from the bank does comply with the requirements of condition 15. License. Just looking, we can look at that letter. It's at page 390. It's a letter from, as you see, the managing directors of Bank of America on one hand and the general manager of the Bank of England on the other hand, Bank of India. And really, it's not necessary to read very much of it, but it doesn't go very far. It simply says, we would like to indicate, as page 390, our interest in actively pursuing further discussions with you in relation to the transaction, and amongst other things, our interest in working with you to carry out initial due diligence and to assist in developing a mutually agreeable financing scheme. It suggests that that letter was compliance with condition 15, is plainly unsustainable. The case appears to have changed before the Supreme Court because everything was then considered to depend upon a letter of comfort. And this was a matter which was very much in dispute. I think the easiest place to see what the ambit of the dispute was is the agreed statement of facts and issues. And at paragraph 26 on page 1032, there's a summary of the position. We're talking about the 15th, the 16th of January, 2015. On the same day, following a meeting between the Minister of Finance and the representative of CT Power, there are meetings, what transpired is not agreed in the parties' respective affidavits. It is common ground that a letter of comfort was discussed and a draft produced. CT Power maintains that a final draft was agreed, but that this was subject to the caveat that its terms might be varied, amended, or modified by the issuer. The Ministry maintains that a final draft was agreed and that this was not subject to any variation, amendment, or modification. And I've given references there to the various versions of the draft of the letter of comfort. And it's, I think, from our point of view, we can see that there were changes. Page 393, I think, is the version first version, the version I think that the respondent relies on is at page 394. You'll see that there's been crossed out. And there's a particular provision in relation to anti-money laundering. In the version which the respondent says was agreed, at that point is at page 543, in which you'll see that those lines are not struck out. There is also the curious feature.
And I'm sorry, what's the relationship between these two documents you've just shown us? Is 543 the version that the government says?
The version the government said was the draft which was agreed when the discussions took place.
Is 543?
It's 543. And that's exhibited to an affidavit of Mr. Sundram, who was one of the deponents who put in evidence on behalf of the government. But I was going to just advert to the rather curious feature that I don't think the Supreme Court dealt with, but we say is important. The respondent's evidence, summarised in my entry on the in the entries in the agreed facts and issues, is that the respondent says that the draft was in any case subject to more or less anything that the issuer of the draft wanted to put in. The evidence of that is in the affidavit of this is Joe here for CT Power, which you'll find at page 266. She says in terms, after several amendments, a final draft was agreed, subject to the caveat that the issuer of the comfort letter could vary or modify, amend or modify the terms discussed in order to comply with applicable regulations and legal advice. And then she produces the drafts that I showed you. The actual comfort letter is at page 396. It's from an organization called Avendus.
I'm so sorry, can you give me the page number again?
396.
Thank you.
Can I just check what's happened to the shape of the case, if you like, by this stage? Because you've referred us to the Bank of America and Bank of India letter. You made some points on that, but that just seems to have dropped out of the proceedings. You're not maintaining, are you, that we look at that and say, well, whatever we think about the Avendus letter, the Ministry of Finance was entitled to reach the view it did by reason of the Bank of America letter. The case seems now just to be focused on the Avendus letter.
Well, we'll see in due course what the court said about it, because it's that obviously the judgment which we're challenging.
Right, but I was actually
asking about the focus seems to have changed, but right up until the hearing, it appears that the respondent was saying, yes, well, condition 15 was satisfied by the Bank of India's letter.
Right.
And it was our case. Well, of course it wasn't, because they don't begin to satisfy condition 15. They then said that it was satisfied by the Avendus letter. We say, first of all, that the Avendus letter didn't conform to the draft. And also that, as you'll recall, there was the additional requirement from the government's point of view that the respondent should identify the source of its funds. And that is a dispute which the Supreme Court simply didn't
I appreciate you're going to come on and explain that, but my question really was, do we just now ignore, in effect, the Bank of India, Bank of America letter point, because you don't seem to be raising it as a reason why the Supreme Court went wrong?
Well,
your argument
can I just hold
on
fire on that for a moment, because I'm going to come to the Supreme Court's judgment on that point, but I'm just trying to remember in my own mind what the Supreme Court said, if anything, about it, so I don't want to, if you like...
Just before we leave the two letters, the bank's letter seems to be about the loan finance.
I'm sorry?
The bank's letter seems to be about the loan finance, the loan element of the finance, and this letter is about the equity element of the finance, isn't it? So there are, if you like, two different slices of the total finance cake.
Except that the bank letter was not committing the banks to anything.
No, I'm not talking about its quality. I'm just talking about its subject matter. And the banks are saying what they might be prepared to contribute by way of loan. And this letter, both in its draft form and in the format as issued, is about what the company is going to stump up by way of equity contribution.
Yes. And it's if you like, the underlying fundamental objection to the letter, quite apart from the detailed objections that it doesn't conform to the draft in any case, that it does not deal with the source of the funds which are going to be used, and that is what
But that's the source of the funds for the equity.
Yes.
On my understanding.
Yes. And
I think, my Lord Briggs, and it's an aspect of my just wanting to understand, is raising. It seems that there was to be debt funding and equity financing for this project. The bank letters, Bank of India, Bank of America, seem to go to the debt element. This comfort letter, the Avendus one, and the drafts that we've seen seem to go to the equity element.
Well, yes.
And do we just focus on the equity element?
No, I think we focus on whether or not condition 15 is satisfied. That is in the terms. It is, as you've seen. And it's the appellant's position that it never was. It was the first thing that the respondents attempted to say was that it had been satisfied by the bank's letters. Well, that's obviously wrong. And then they say that it was satisfied by the vendor's letter, and we say that that is wrong as well, because it didn't identify the source of the funds, and it didn't conform to the drafts which had been agreed. And at that point, I wanted to come to, well, I can perhaps, in the interest of keeping this as short as possible, remind your lordships that this is dealt with in paragraphs 56 and thereafter in our written case. But looking at the judgment, it is dealt with from pages 841 to 845. It talks about procedural fairness. The two cases which are referred to by the Supreme Court are Coughlin, which you may recall involves patients at nursing homes being moved without any process, and the Attorney General of Hong Kong and Young Shu, which involves the status of immigrants in Hong Kong and promises which have been made to them. But we would submit that there's no basis for the generation or existence of any legitimate expectation in the present case. I mean, where is the unequivocal promise, so to speak, to put it in shorthand terms? There simply is none. And the decision of the Supreme Court is simply demonstrably wrong on this point. There is no legitimate expectation that we would accept the vendor's letter of comfort, which was not in the form of the drafts which had been agreed. And the conclusions of the Supreme Court at paragraph 53 and thereafter, which really just recite what was apparently submitted by C.T. Power at paragraph 54. These are not simply maintainable. It is not, in our respectful submission, the case that C.T. was only made aware very late in the day of the reasons for the rejection. A lot of these matters were, frankly, simply matters of dispute, which the Supreme Court appears to have assumed should be decided in C.T.'s favour. And in paragraph 56, the question is whether, in the light of the circumstances of the present case, C.T. Power has a legitimate expectation to be consulted before the rejection of the letter of comfort. Well, this is simply unjustified, so to speak, trying to shoehorn disputed facts into a wholly inappropriate context. To say that fairness would require to be informed why a letter which was not in the agreed form is not in the agreed form, well, I think your Lordship will have the point that I'm seeking to make. I'm very grateful for you allowing me to go on a little beyond 2 hours.
Well, you've done very well considering the interruption that we had earlier.
Well, I'm also grateful. I'm also grateful that your Lordships hadn't been more critical of our documents, which I'm afraid have involved chopping and changing and moving around in a way which I would have preferred to avoid. Those are my submissions.
Thank you very much, Mr. Guthrie. Mr. Chetty.
My Lords and my Lady, I shall be very brief. In light of the helpful submissions made by Mr. Guthrie for the appellants, I will begin with condition 15 and leave it. I believe that some dates are quite important in order to situate the condition 15 as well as the implementation agreement. The letter from the Bank of America and the letter from the Bank of India comes on the 10th of October 2014. Then the next important event is the meetings of the 15th and the 16th of January between the parties in order to come up with what is called the bank comfort letter. Then we have the letter from Amendus in February 2015. And we have the joint discussion draft agreement concerning the implementation agreement in July 2015. And the draft implementation agreement in its clause 7 tends to refer and to incorporate condition 15 into that draft agreement, with one addition that City Power will be given a period of 9 months in order to comply with condition 15. But the events as they unfold is that if condition 15 needs to be satisfied from the date of signature of the implementation agreement, and you have a period of 9 months to satisfy that condition, the fact is that a letter was produced in October 2014 already, purportedly to satisfy that very condition. And a second document is produced in February 2015, again purportedly to satisfy that very condition 15, which is still being debated as at July 2015. Therefore, there seems to be a mismatch somewhere. And furthermore,
Sorry, you talked about July 2015, and I think you said that the draft agreement was July 2015, but I think it was 2014, wasn't it?
sorry, it's your the point I'm making is that when the meetings took place in 15th and 16th of January 2015 between the parties, paragraphs 2 and 3 of that draft letter refers to two different conditions. Paragraph 2 refers to the condition that City Power has to prove financial capabilities, and paragraph 3, the Manda's submission clearly brings in an obligation to prove the source of the funds, in that the funds should not come from activities which contravene anti-money laundering legislation and should not come from illicit activities. So that condition was already in knowledge of City Power as far back as the 16th of January 2015. So that when the appellants took the decision that condition 15 has not been satisfied insofar as proof of source of funds is concerned, the appellants are fully justified to take that stand. And the respondent, City Power, has no cause to complain that this is either a new condition or they should be given time to comply with that condition, because right from the 16th of January 2015, they knew about this condition. And their approach to that condition has already been highlighted in the statement of facts and views at number 26, already referred to by Mr. Guthrie. And it is also, their stand as regards that draft letter is also encapsulated at paragraph 35 of the affidavit of Mrs. Jawaiya at page 266. Whereas in the statement of facts and issues, the approach of City Power seems to be the following, that when we were discussing the contents of a comfort letter, we were at liberty to walk out of the negotiating room and change everything in that comfort letter. This is what is borne out at number 26 of the Statement of Facts. Whereas, well, the obvious point is, why do you come to a negotiating table if you can leave the table and change everything in the document you're supposed to come to agreement to? The position is slightly different in their affidavit at paragraph 35, page 266. The position of City Power is that, as regards the bank comfort letter, they've given themselves the liberty to vary the contents in a limited way. The variation here is limited to make provision corresponding with applicable regulations as well as legal advice from counsel. So these are the two restricted variations that you can bring to the comfort letter. And those two variations do not touch upon source of funds, and it cannot be. And therefore, to that extent, condition 15, as claimed by the appellants, has not been satisfied. This is the submission I wish to make as regards condition 15, in addition to the points already made by Mr. Guthrie. Now, very shortly again, as regards the implementation agreement, it is my submission that the Supreme Court of Mauritius takes a rather restrictive view when it reads clause 12 of that particular implementation agreement. What the court seems to say is that because of the environment of negotiation between the parties, it must be the case that the appellants were exercising public powers and were doing public acts. And when we consider the implementation agreement in that particular context, taking into account in particular clause 12, the Supreme Court seems to say that clause 12 acts as a deeming provision, in the sense that if ever there is a breach, the appellants who have been exercising public powers and public acts cannot raise their sovereign immunity in order to ward off any action, any civil action contemplated by City Power. So it's a sort of deeming provision which changes the status of the appellants for civil litigation. But that cannot be. From the very wording of clause 12, the wording expressly says that for the execution, delivery, and performance of the agreement. Therefore, the reading of the Supreme Court in their judgment at paragraph 42.
What's the page number, please?
Page 840.
Thank you.
Is, in my submission, rather restrictive in the sense that the Supreme Court tends to concentrate on the default position of the appellants. That is, if ever the appellants are in breach of their obligations under that act, then they should be treated as private individuals rather than entities exercising public powers and doing public acts. And this, to a certain extent, does some violence to the two key words, execution and delivery of the implementation agreement. So that my submission is that the implementation agreement is to be taken as a private and commercial document for the whole gamut of the provisions under the implementation agreement. And clause 4 adds force to that particular point in the sense that clause 4 of that implementation agreement in fact gives the very essence of the agreement. The agreement provides for the management of payment obligations. and nothing more. City Power will be providing services to the CB, respondent number 5, co-respondent number 5, and the co-respondent number 5 is under an obligation to pay for those services, which to a certain extent joins Lord Reed's example of the catering services. I mean, services are being provided and you have to pay for it. And clause 4, in effect, provides for the mechanism of the management of such payment obligations. And what happens is that if ever now the CB would default on those payment obligations, there need to be some sort of security. And this is where the appellants assume the role of guarantors, and more importantly, as co-principals and as co-debtors, so that if ever the CB falls out of the picture, the government, as purchaser of services, is legitimately to be invested with the obligation to pay for those services. So to that extent, therefore, clause 4, giving the essence of that implementation agreement, which is still in draft form, clearly shows that this agreement is of a commercial nature. But there is more, in the sense that if we turn now to clause 7 of the implementation agreement, clause 7, 7.1, 7.2, and 7.3. 7.1 and 7.2, as I started early on, tends to incorporate condition 15 into that agreement.
I'm sorry, would you just remind me of the electronic page number, please?
It is Annex 19.
431. Thank you very much.
Mr. Guthrie has already highlighted that this condition 7 is not to be found in the earlier versions of that draft agreement. In Annex 19, it's for the first time that this clause 7 comes into play with a note. And one can guess that the note comes from City Power rather than from the government, because it says that this clause 7 is being drafted in this way in order to meet your requirements. Now, clause 7.3 provides for an avenue where the agreement can be terminated. Of course, a reading of clause 7.3 provides for a non-controversial observation that clause 15 has not been satisfied, has not been complied with. Therefore, the agreement is to be deemed terminated without any claim for liability from either party. If we tease that clause 7.3 a bit, let us say that there was the implementation agreement duly executed, and for some reason, the government decided to act in breach and to terminate for no valid reason. I humbly submit that clause 7.3 provides for a private law remedy in that particular situation. And to that extent, one cannot color the acts and doings of the appellants in such a way as to bring it within the province of purely public law elements. These are the 2 points I wanted to make, my lords and my lady.
Well, thank you very much.
Assistance.
Thank you, Mr. Chetty. Mr. Bassett.
My lady, my lords, I intend no disrespect, but may I address the board whilst remaining seated?
Yes, certainly. We entirely understand, Mr. Bassett.
Thank you. I'd like to tackle head-on the submissions made by Mr. Guthrie and Mr. Chetty concerning the fact that we have been seemingly riding two horses at the same time, that we started judicial review proceedings when we fully knew that our recourse would be a private law claim in damages. Let me at the outset state that this was never the correct position of the respondent. In fact, as we've pointed out in our written case at MS 1091 and 1093, in paragraphs 90, 91, 93, 95, and 96, without the review proceedings, the respondent would never have been able to know the essential facts in order to bring a private law claim against the state. And I will explain why. Lords, after the general elections that took place in Mauritius on the 10th of December 2014, having read what had been reported in the local media on the 27th of December 2014, and your lordship and my lady will find it at MS 392, MS 392. This is a press article in French where the newly appointed Minister of Energy made certain statements to the effect that all contracts concerning the construction of the power plant of City Power had already been approved by the departed government. And he says all contracts had been signed depuis belle lurette, since long time. There's only the financial aspect of the question which remained to be finalized, and that it would be for the Attorney General to advise on this matter. He goes a bit further, states that he finds that Ramgoolam, the ex-Prime Minister, had caused all contracts to be signed before leaving power, but he did not want to draw conclusions for a moment. So having taken cognizance of such a statement, the representatives of City Power chose to engage with the new government, and indeed meetings were held with both the ministers of Finance, Energy, and the representatives of the Ministry of Finance. And those discussions were led by the topmost officer, the financial secretary, who finally produced that draft of the letter of comfort. Now, having engaged with the ministries and having submitted on the 27th of February 2015 a letter of comfort, City Power remained completely in the dark about the fate of its project that had started some 9 years before, that had been encouraged by government, that had obtained the imprimatur of government through various bodies, be it the Board of Investment, the Ministry of Energy, the Ministry of Housing and Lands. So, being totally in the dark, not having received any communication, whether written or verbal, from the appellants, the respondent then came across an intervention in Parliament by the Minister of Energy. And this intervention did not come from the Minister of Finance, who was responsible for ascertaining whether Condition 15 had been complied with, but it came from the Minister of Energy. Now, let us look at that statement, my Lord. It is produced in the judgment of the court at MS 83B, MS 833, paragraph 18. So, in answer to the private notice question from the leader of the opposition and referring to Condition 15, the minister stated in the National Assembly, as at today, the promoter has not met this condition. But it goes further. He states, on the 6th of February, government has decided that the company should state its source of funding. Now, I must confess, I'm a little bit surprised by the submission of Mr. Chetty, who says that ever since the 16th of January, City Power had been made aware that it should disclose its sources of funds when the Minister of Energy himself tells the House on the 6th of February, government has decided on the 6th of February that the company should source of funding within a reasonable delay, failing which the project not be implemented. Up to now, no letter of comfort has been communicated. Insofar as my ministry is concerned, it intends to recommend to Cabinet that government does not go ahead with the project. So when we apply for leave for judicial review, the City Power, in its motion paper, asked in its prayers for a declaration and also for a mandamus, because it hoped at that stage that it would be able to proceed with the power plant project. But of course, the decision of the had already been taken that the project should be aborted. When we applied for leave, we were met with the obstacle: you have not identified any decision. What is the decision which you are asking to be judicially reviewed? And see that at MS 187, 188, and 191. The court page. Last sentence. It is important that the decisions in which judicial sufficiently identified, and once the decision or decisions have been identified, the court is asked to quash the decision or remit the back to the decision maker. These are the submissions of Mrs. Green Joku on behalf of the respondents. Page 188, we have it. There is no indication of the decision or decisions which are sought to be quashed. Further on at page 189, line 10, the crucial issue here, I would ask, which decisions or actions is this application for judicial review being lodged against? And then reference is made to the website of the Prime Minister's Office of the 13th of March. And we are asked, is this the decision? Is this the decision? So, my humble and respectful submission to the board would be, without applying for judicial review, the respondent would never have known why it allegedly had not complied with one of its license conditions, and why a project it had started 9 years before should ground to a standstill. Before entering the review application, City Power was not told what the alleged shortcomings.
Mr. Bassett, can I just interrupt? We're having a little difficulty with our reception just now, and we've also passed the time when we would normally adjourn for our lunch. So we'll adjourn just now for an hour, and we'll ask our technical people to check the connection for the sound quality. So we'll look forward to hearing from you again in an hour's time.